entitled Katie Orost versus Jay Orost, case number 24 AP 010. Representing the appellant, Jay Orost, is attorney Harold B. Stevens III. Representing the appellee, Katie Orost, is attorney Charles S. Martin.
Thank you, and good morning, everybody. We'll hear from counsel for the appellant first, of course. Please identify yourself and your client and then proceed.
Attorney Harold Stevens for Jay Orost. Good morning, Your Honors. Thank you for allowing us to attend.
Thank you very much.
May I proceed?
Yes, please go ahead.
So I'm representing Jay Orost. He's now 63, and he was married to Katie for many, many years, and they have 4 children. They had a house and 9 acres. And basically, there were allegations that he abused one of their younger daughters during their marriage, and they got divorced. And basically, after a couple of days of hearing, the family judge, basically Judge Bent, awarded Katie, who is now age 44, over $850,000, which consisted of their 0.91 acre house, equity, a 9-acre lot, Jay's 86,000 IRA, and then she got to keep over 299,000. And this was based basically on the finding where there was no evidence that Jay had somehow abused Katie. Katie testified that she had a happy marriage. So somehow we feel that the judge was prejudiced by some of Mr. Martin's argument. I claim that this was a typical picture of an abused woman and the model of coaching and taking over a person's personality. But there was no evidence of that presented. So our whole argument is that the matter should be reversed and mandated to give a more equitable distribution. Basically, Katie got 90% or almost 95% of the family assets, and Jay got nothing, basically. And he's 63 years old, and he's got another 15 years to live with no place to go and no money, although he is in jail for abuse claims against his daughter. So I'm going to reserve 2 minutes for the rest of my time for rebuttal. Thank you.
Okay, thank you very much. We'll turn to counsel for the appellee. Please identify yourself and your client and then proceed.
Charles Martin. I'm the attorney for Katie Orost, the appellee.
Thank you.
The argument that I heard was that there was no evidence to support the court's finding. I beg to differ, and in my brief, I pointed out all of the evidence that, in fact, did support the findings. And I would point out that, number one, I presume the standard that the findings stand unless they are shown to be clearly erroneous. Point number two, nowhere in the presentation, either in the brief of the appellant nor in the appellant's argument, is there a demonstration of any abuse of discretion on the part of the trial judge. I believe those 2 points of law prove fatal to appellant's argument. Otherwise, I simply rely on the brief that has been submitted.
Okay, thank you. How much time does the appellant have, please?
Appellant has 2 minutes and 56 seconds remaining.
Counsel?
Yeah, so thank you, Your Honors. Well, Mr. Martin hasn't given one example of any sort of direct or circumstantial evidence that would show that Katie had nothing but a happy marriage. She repeatedly testified that her marriage was a happy one. She never testified that it was an unhappy one. She never testified that she was abused. So basically all of Mr. Martin's references are to a bunch of inferences that are not based on any sort of fact. So,
Mr. Stevens, can I ask you a question? There are factors the court considers when disposing of marital assets. I don't recall whether it was a happy marriage or not being one of them. What factor would that fall under?
Well, that's a good question, because basically the judge found that Jay Orost had abused Katie, not only when he was his adopted daughter, but also throughout their marriage. And there was simply no evidence of it. And basically the award, this whole award is based on fault. And we've argued that fault should be really one that's based on the party's finances, even assuming that there was abuse. That didn't really affect the family's finances at all. And that's the point we're trying to make. And I've cited some cases that say, look, you don't want to get involved in obviously why the parties are getting divorced is obviously they're getting divorced because they don't like each other, they don't have problems, or their marriage is falling apart. But you don't get into the nitty gritty of who said what to who unless it's really affecting their finances. I mean, obviously they're not getting along, or they didn't have a good relationship, and so this Judge Bent basically put all the onus on Jay.
You have 1 minute remaining.
Okay. So anyways, in answer to your question, fault can be considered as one of the last factors in deciding how to award family assets. And in this case, the judge went overboard, in my opinion. Thank you.